guys are preparing for the upcoming deadline. So September 30th is here. A lot of people are trying to file their cases to avail themselves of the grandfathering protection. Now, it is important to remember that the EB-5 program will continue to operate even after September 30th. The only thing that's expiring in September 30th, 2026 is the grandfathering protection, right? So, whether or not it makes a huge difference to you is only for you to determine. Many investors are still going to continue and file their petitions next year with the assumption that Congress is going to renew the program in September of 2027. But for those of you who are a little bit more risk averse, and if you can file your petition by September 30th, 2026, this grandfathering protection obviously is a really great bonus. It essentially guarantees that you can finish your immigration process even if Congress doesn't continue to renew the EB-5 program in the future, right? Those investors who file without this grandfathering protection, that doesn't mean they won't be able to finish their process. It's just an unknown, right? If Congress, in the unlikely scenario that Congress doesn't renew the program, those investors are going to be in a more uncertain situation, right? They may be able to finish the process, they may not, but those who file by September 30th, 2026, for sure, legally are allowed to finish their immigration process. So we're heading for the September 30th deadline, and I'm starting to hear this from attorneys and from investors saying, well, how much do I really have to get done in the next few weeks? Can I essentially file what we call skeleton petitions? A skeleton petition is something where you provide the bare minimum information. So you provide the forms, proof of investment, and some source of funds documentation, but maybe you don't provide all the detail that you would normally have in a fully well-finished petition. And I am posting this video to discourage you from doing skeleton filings. Let me explain why. Rules have changed, and how USCIS adjudicate this petition has changed, and now they will very likely deny any petition if they believe that you did not provide sufficient evidence from the beginning. And why they will deny it? Because they're using a legal provision that says the EB-5 investor has to qualify at the time of filing their petition. Right? So now when they see a skeleton filing with very little evidence, they're using that language as a basis for a denial, saying, if you didn't meet your burden of proof at the time you were filing your petition, you technically did not qualify at the time of filing, right? And so even if you're able to provide this information later, they can use this provision and say you didn't qualify at the time of filing. Now, is that legally accurate? That's questionable, but that is the trend that we have seen happen. So let me explain. Practically speaking, a few years ago, 5-6 years ago, as long as you got your forms in, and as long as you provided just bare minimum evidence of your investment in the lawful source of funds, when an officer would be adjudicating the petition, if they deemed that you didn't provide enough evidence, they would send a request for evidence, and that would give you 90 days to respond and add additional information. If they still thought there was not sufficient evidence, they would send you then a notice of intent to deny, a NOID, and that would give you an extra 30 days to add more information, more documents, and more evidence to support your case. And only if at that point they still didn't think you met your burden of proof, then they would issue a denial, right? And then during the denial, you can actually file a motion to reopen and provide even more evidence, showing that you were entitled to the EB-5 benefit. But that's why a lot of attorneys a few years ago actually felt comfortable. In order to meet the deadline, they would file what we call a skeleton petition, so the bare minimum, just to get your application in before the deadline, assuming that USCIS was going to send a request for additional evidence in the future. Here is the problem. That is no longer how USCIS operates. They started issuing straight denials with no request for evidence and with no notice of intent to deny. Sometimes they start skipping the RFE, the request for evidence, and will issue a notice of intent to deny, which does give you 30 days to respond, but 30 days is not a lot of days to respond if you need to collect a bunch of documents. So, long story short, today, if you're filing an EB-5 petition, I would say you want to include a piece of evidence for every single thing you're trying to prove in the initial petition. Maybe you want to collect more evidence, but I would say include at least one substantial piece of evidence for every claim. So I'll give you an example. If your source of funds, your $800,000 comes from, $200,000 comes from a loan from your uncle, $500,000 comes from savings from your income, and $100,000 comes from land you inherited, right? There's 3 separate sources. You want to include information, on the lawful source of funds of your uncle's loan, right? You don't want to have a situation where you just show the salary in the uncle's loan and provide no evidence for the $100,000, that you inherited, hoping that they're going to send you a request for evidence later, or saying, I've proved most of it, just $100,000 I didn't provide evidence for. They can use this against you. They can say, listen, we had nothing on this $100,000 piece. You provided no evidence at the time of filing. Therefore, you were not eligible at the time of filing, even if you provide this later. That is a claim that may likely get made. So if you are collecting documents and you believe that given more time, you could collect even more proof, but you don't have time before September 30th, at least provide some substantial evidence in each category, right? Because what is enough and what is not enough, that is a subjective standard that can be adjudicated differently. But if you provide no evidence for any piece of your source of funds, like if you just skip it at all, then objectively speaking, they can argue you didn't meet the burden of proof at the time of filing. So provide some evidence that the $200,000 were lawful, some documentation for that, some documentation for the salary. So for example, your tax returns and a letter of employer. Maybe you have additional documents like bank statements or something else, but as long as you provide some documents that make it more likely than not that those funds are lawful, then it already helps that filing to be substantiated, right? Can it be further improved? Sure. But at least you want your filing to be substantiated at the time of filing. So that is kind of my recommendation. Now, another thing to keep in mind that the current filing does allow you two options. So it does actually give you a little bit more time than just September 30th. September 30th is when your forms have to be submitted. If you're doing a paper filing, so forms and evidence in a paper format, then everything has to be in by September 30th. However, if you're choosing the electronic option, then September 30th is when you have to submit the forms, and on the forms there's a question, are you submitting all the initial evidence with your paper filing, or are you going to upload your initial evidence through a USCIS portal? If you select that second option, that you're going to upload the initial evidence through the portal, that actually gives you more time, because that means you just have to submit the forms by September 30th, and then you have to wait for the receipt notice to come from USCIS with the case number. And once you receive the receipt notice, you can go to the USCIS portal and submit your initial evidence through the portal, right? So for those who feel like September 30th is really pushing the limit on how much evidence they can collect, and they feel like they can collect even more evidence after September 30th, choosing the upload your evidence through the portal does buy you those few extra weeks, right? But my recommendation would be you want to submit your initial evidence no more than 30 days from when you filed your initial petition. There's no set timeline on USCIS website, but a common agreed upon kind of standard is 30 days. Also keep in mind that you do, there's some argument about whether or not you need the receipt notice to properly submit evidence, but I think for practical purposes, you kind of do need to receive that receipt notice. So that does buy you a couple of weeks from when you submit the forms to USCIS to when the receipt notice comes in. So then you can use that receipt and upload your initial evidence. So that would be a tool that I would recommend utilizing if you believe that you need a few more extra days past September 30th to maybe gather or organize your evidence. So choose the option that allows you to submit it a little bit later through the portal, but absolutely do not submit skeleton filings, right? You do not want to be submitting, saying I'm submitting all my initial evidence in the initial filing, and you're submitting the forms and some financial documents, but not all of it. So just please keep that in mind. Again, denials without our fees, denials without NOIDs have been unfortunately very common in the EB-5 world in the last fall and winter, so starting with fall of 2025. And we have seen it across all immigration practices. So for other cases as well, attorneys have been reporting that normally where they expect to receive requests for evidence or notice of intent to deny, those were not granted. And USCIS has put out some language and memos and alerts saying that if people are going to be filing petitions without substantial initial evidence, those petitions can be treated as frivolous, and frivolous petitions not only would be denied, but it potentially can have a negative impact on your future petitions for immigrant visas or applications for non-immigrant visas, because it's basically like a negative record. So definitely not something that I would recommend. So what can you do? Present some documentation for each part of your transaction, right? It may not be all documentation that you can possibly gather, but some, so that you can confirm each statement. Again, if it's a transfer from, a salary, tax returns, letter from the employer, if you don't have time to obtain a letter from your HR or from your employer, copies of pay stubs, maybe a contract like your employment contract. If you're borrowing money from a relative, their tax returns, kind of your loan agreement with that person. Try to obtain that evidence as quickly as possible. And another thing that I highly recommend is, right now, I know everybody's kind of worried about picking the right project, and we as investment brokers are available to help. We have been doing due diligence on projects all year. I literally have multiple options that are 956F approved, rural projects, as well as signed employment TEA projects, 956F approved, have spots for investors, strong financial structures. Because we've been doing this work for months, when an investor comes in, within a few hours of conversation, we can help them pick a project, right? So this is a good time to utilize professionals, because if you start from scratch trying to research projects now, there simply won't be enough time to do proper due diligence before September 30th. So utilize professionals who have already done due diligence so you can go through these options. But I've been telling all my investors, we can get you situated and we can talk through project options with you quite quickly. Your immigration attorneys need a lot more time because they have to sift through hundreds of documents anew. And so you want to make sure that if you're starting your EB-5 process now, 5 weeks before the deadline, that you really focus on presenting all the documents your attorney needs in the next week. And while your attorney is working through those documents and organizing and putting together your source of funds petition, you're working with your FINRA licensed professional on selecting a project, which you can do in the first couple of weeks of September. Then by the time your project is picked, your attorney is going to be done with your source of funds documentation, and you can wire hopefully by mid to somewhat late September and get your filing in timely. So I hope this session helped. Once again, please don't do skeleton filings. Will not be able to get away with it anymore. Like back in the day, practically we saw that people were able to. Do not rely on the fact that USCIS will send you a request for evidence. That is not standard practice anymore. We can legally argue that it should be, but that is currently in 2026, USCIS does not send requests for evidence in every case, and they do not send a notice of intent to deny in every case before denying the actual case. And even if you are able to argue in court that they should have given you an opportunity to present additional evidence, if your filing was completely unsubstantiated, so if your filing had no basic evidence on the day of the filing, then that can be used against you because they can argue that you simply didn't qualify at the time of filing. So even if you improved your petition later, at the time of filing, you did not qualify. So I wish everybody luck. If you need professional assistance in selecting a project, please feel free to reach out. If you're struggling finding an attorney who knows EB-5 and still has capacity to take clients, also let me know. I know a few practitioners who are still accepting new clients, but many firms have stopped accepting clients now that we're 5 weeks out. But yeah, feel free to reach out and ask your questions.